Good afternoon to those of you in Washington, D.C., and Venable's D.C. offices who joined us here for lunch this afternoon, and good afternoon and good morning to those of you on the telephone from across the country. We have a nice-sized group here in Washington, D.C., and we have an extremely large group of about 260 people throughout the country that have joined us for today's program, entitled Keeping Up with Technology and the Law, What Your Nonprofit Should Know About Apps, the Cloud, Information Security, and Electronic Contracting. My name is Jeff Tenenbaum, the chair of the Nonprofit Organizations Practice here at the Venable Law Firm. Thank you for joining us. As many of you know, because many of you are regular guests of ours, this is part of a monthly series that we do on nonprofit legal issues that we've been doing for about 2.5 years now, trying to cover the waterfront of a wide variety of issues, legal issues that affect nonprofit organizations in various ways. We have covered certain issues in the social media area, copyright, trademark area, technology-related transactions generally, but today's program is going to tackle some of the most cutting-edge issues in the technology space that affect nonprofit organizations, issues with an area in which we do an extensive amount of work with hundreds of nonprofit organizations each year. And our speakers today, two of my colleagues, are two of the folks who do much of that work with our clients. So they have the benefit of much experience in working through all aspects of these issues with a wide variety of nonprofit organizations, and you'll have the benefit of that today. Before I introduce our speakers, a few housekeeping tips. We do have a lot of material to cover today, a little bit more than some of our programs, so we are going to have to ask you to hold your questions until the end, but do make a note of them. I'm sure you are going to have a lot of questions, and we are definitely going to leave time for questions. As a result, our speakers are probably going to have to skim over a few of the slides that are perhaps some of the less important slides, but you'll have all that in your materials to take a look at. Those of you here in the room have a printed copy of the PowerPoint presentation along with the full speaker bios and some ancillary handout material, some articles that our speakers and others here at Venable have written on this and related topics. And those of you on the webinar should have had the PowerPoint presentation emailed to you. And as many of you know, tomorrow you will all receive an email that contains a link to the recording of today's program along with the streaming PowerPoint presentation, all of the handout materials, etc. Feel free to share that with colleagues and others who you believe might benefit from the program. Preview of some of our upcoming programs, and we actually have all of our programs for the balance of the year scheduled. And there's actually a second one here, and I'll get you the date a little bit later. We should have put it on here. In early October, we're doing a program, kind of a bonus program, so to speak, not part of our usual series, and it's really targeted at trade and professional associations specifically. Probably doesn't have much relevance to other nonprofit organizations, and I can't recall the exact title, but it's focused on information exchanges in the trade and professional association world. On the legal side, with a focus on the antitrust issues and risks that come along with exchanging information within the context of a trade and professional association, a very important area for associations that do get involved in activity, and many associations do. And then we're going to have some folks from Verus Consulting joining us to talk about some of the non-legal issues that come into play. But a very interesting program in early October. It might be October 8th, but I'll confirm the date. Then on October 24th, our program is entitled The IRS Final Report on Nonprofit Colleges and Universities, Lessons for All Tax-Exempt Organizations. On November 14th, it's not listed here because it's not posted on our website yet, but it will be in the next few days. We have a program entitled, or at least working title is Donor Intent, Restricted Funds, and Gift Acceptance Policies, What Every Nonprofit Needs to Know to Effectively Accept and Utilize Contributions. And finally, on December 5th, our program will be entitled Work and Family, What Nonprofit Employers Should Know About Family-Oriented Employment Laws. So as you can see, we do work hard to try to cover a wide variety of issues, and we've gotten some terrific feedback from many of you that seem to be pleased with the program that we're doing, and we really appreciate that. Our speakers here today are running out of time, so I don't really have time to go through their bios. I would encourage you to take a look at both of their bios in your handout materials. But to my immediate right is Krista Coons. Krista works in our New York office, has been with Venable for, what, about a year now? About a year. A terrific addition to our firm, does an extensive amount of work in the technology-related area, deals with intellectual property issues such as copyrights, trademarks, defamation, privacy, and all the related fun issues that go along with that, and also has really developed an expertise in in working with clients who are developing apps, which is one of the things that she's going to focus on here today. And to Krista's right is AJ Zatola. AJ is a partner here at Venable in our, what do we call it, outsourcing and technology transactions, something like that. Forget transactions and outsourcing. Technology transactions and outsourcing. All things technology is the name of that practice group for today's purposes. AJ is a real star here at Venable. He and I have worked together for almost the whole time that I've been at Venable. He's been our go-to person on kind of everything technology related and many other things as well, and has worked with hundreds of our nonprofit clients on all of the issues that we're going to be talking about here today, and many ancillary issues as well. AJ is a regular speaker at these programs. You may recognize him from prior presentations, and we're glad that he's with us here today. Promise, AJ, I won't ask you to do any more speaking presentations for the balance of the year. Until next week. Okay. Well, with that, we're going to get started. I'm going to turn it over to Krista, who will get the program underway. Krista?
Thanks so much, Jeff, and thanks all of you for coming here today, and to those of you who are listening in on the webinar. I'm going to start today with talking a little bit about apps and the creation and development of apps, and in particular what issues might stand out for nonprofits. A lot of you, if you're like me, might feel like the term app went from being sort of a fringe, like techie word, to being ubiquitous in a matter really of what felt like minutes. And I think we feel that way because that's not in fact far off. Right now we're at a point in time where folks spend about, on average, 2 hours a day on apps on their mobile devices, which is over double what they were spending just over a year ago, and significantly greater from 2 years ago at that time. So really the rise of apps has been something fairly extraordinary. I think as a result, it's left some of us feeling a little bit in the dust about what exactly they are, how they're different from a website, what issues I need to be attuned to if I'm thinking about deploying one for the use of my nonprofit. So a quick basic primer on what an app is. It's a software application that's designed to run on a mobile device. You get an app through a distribution platform that is unique to the operating system on your given device. So if you've got an iPhone, you've got to get your app from the Apple App Store. If you've got an Android phone, you have to go to Google Play, which is the rebrand of the Google App Store. That actually sort of ties into one of the main purposes of an app, or one of the main benefits of an app, which is because the app is designed to run specifically on your device, there's a much greater functionality than you get on a standard website. The website has to run, of course, with all browsers, all hardware, all operating systems, and so there's really only so much you can do. It's pretty constraining from a development perspective. But with respect to an app, you can really, the user interaction becomes much more specific and much more tailored because the app itself is designed to be tailored. In that same vein, apps allow you to sort of do push notifications to users, so you can really interact with them daily or regularly on a one-to-one basis when something unique is happening for you, when there's a big test, you're testifying on the Hill, or your organization has a bill in Congress you want folks to be aware of. You don't have to wait for them to come to you. Depending on what your terms say, you can give them a push notification that sort of highlights for them what's going on. Really makes it a much more invested relationship with the user. Of course, the development of an app comes with a ton of legal considerations, and I think chief among them, of course, has to be intellectual property. Intellectual property, some of you may know this already, sort of falls into three buckets. The first one, copyright law, tends to protect tangible expression. So it's the actual code underlying the app, as well as the images and the text that the user sees when they look at the app, and the look and feel. The trademark law will protect your brand, the brand of your nonprofit, and to the extent you decide to brand the app specifically, it can protect the name of the app. And then there's patent law, which requires that your invention rise to a specific level of uniqueness. It's not really applicable here, but it's hard not to mention in the context of IP. Why does IP ownership matter? IP ownership is basically the only tool you have that prevents other people from using and deploying the same technology that you do. So if you develop an app to get, for example, if you're the Red Cross and you've developed your first aid app, if you don't own it, if you're not protecting it, any other nonprofit and or any other person or entity can go out there and develop and use the same app. They can copy it straight away. IP is what prevents them from being able to do that. And it's important to keep in mind that from a starting point, folks often say, oh, don't worry, I'm not going to, I understand this app is yours, I understand this technology is yours, I have no ownership interest in it. But that oftentimes turns out not to really hold true. I mean, you really need to have your IP rights buckled up, because what folks think at the beginning might not be, what their intentions are at the beginning might not actually turn out to be what their actions say later on. So the first consideration in that vein is who is developing the app and how to make sure that you guys have proper rights to the app going forward. If you have an in-house employee developing the app, which is fairly rare because unlike just developing a website, the development of an app is a little bit more intense and usually requires you to hire a contractor. But if you do have an employee doing it, chances are that your organization has rights to all the technology by virtue of the work-for-hire doctrine. If you hire an independent contractor, on the other hand, you likely don't have any rights straight away to that technology unless and until you get a writing. The work-for-hire doctrine of the Copyright Act says that certain classes of works, including an audio-visual work, which an app would fall under, can be owned by the organization who hires the contractor as long as there's a writing. And the writing has to expressly state that the parties expect this and intend this to be a work-for-hire. A well-crafted and robust work-for-hire provision in your agreement with your contractor should also include an assignment as a fallback in the event that, for example, the app is found not to qualify for some reason as an audio-visual work. You need the developer to have assigned all of his or her rights in that product to you, because you can't ultimately contract around what copyright law says. You have to sort of create your relationship with the developer within the bounds of copyright law.
And the only thing I would add to that is that if you also involve your volunteers in helping to develop that app, which a number of nonprofits have done, obviously you're working with an outside paid contractor to do kind of the substantive work and the technological work, but you may be working with a volunteer committee, for instance, to help develop the features and the functionality and what you hope to deliver. It's equally important to get either a work-made-for-hire agreement or a copyright assignment from those volunteer leaders, because otherwise they are going to be joint authors of that work. They will have joint rights in that work. It can be a nightmare to deal with later, and it's a very easy thing to fix up front by simply having them sign a few paragraph form that assigns those rights to you, to your organization at the outset.
Yeah, that's a great point, Jeff, and it really is that case of where the intentions at the outset don't necessarily match actions at the end, because of course your volunteers want to do what's best for you, and everybody knows that at the start, but if you don't get all of that in writing at the beginning, it really does become a nightmare to have to go back and chase them down after the fact, when at that point in time maybe the app has gained a bunch of publicity and there's some value in it and their tune might sort of change. The other side of protecting your IP is making sure that you're putting out there to the world the IP protection that your technology has. So you may want to consider registering the app for copyright protection. You don't necessarily have to do that. You can register at any time. You always want to use proper trademark symbols when you're talking about your organization and your app specifically. If you've got a registration, that's the R. If you don't, that's the TM. And these are the types of things that you need to keep in mind on a day-to-day, week-to-week basis, because keeping up to date with your with the labeling of your IP laws and with your registrations is something that's ongoing. I mean, to the extent that you do register an app, for example, for copyright protection, every time you've got an update to that app, you're going to want to register the new version. So it's always the current version on file with the Copyright Office. Next, we get to sort of the end user experience. What you want to get from your end user to make sure that your technology is being used in a way that is appropriate to you and is designed to, okay, sorry. I'm being instructed to get closer to the mic. So to make sure that your end user is using the technology in the way you envisioned, any end user license agreement should contain certain standard terms. I'm not going to walk through all of these, but a couple important points to note. Of course, the license can be clicked through. I think most of us are familiar with that concept at this point in time. One catch that you might want to pay particular attention to in the world of apps is that the distribution platforms actually have pretty stringent contractual terms. When you sign up to distribute an app through, for example, the Apple App Store, you've got to agree to a lot of stuff. Apple is very, very rigid about what can be distributed through their store. The types of apps that can be distributed are restricted. In some instances, the potential user base is restricted. And app and I think Google Play as well take a cut of any money that you make. So if you're going to charge for your app, they're going to take 30%. I'm going to talk for a minute about different aspects of those terms that are particularly applicable to nonprofits. But for the rest of the screen, I'll just note you also have to be very particular about data protection and what you're saying in your user terms about how you're going to use the user's data and making sure that you're actually complying with what you say to them. These are the terms on this slide here that I was talking about earlier. These are very particular terms relating that I think have a pretty strong effect in the nonprofit world relating to the distribution of apps through the platforms. The first two, fairly straightforward. Make sure that you're always clear and unambiguous about how you're collecting fees and if you're collecting fees. The last one is the one I'm going to spend a couple of minutes on because some of you may know this already. It's been a pretty hot topic in the news for the past couple years. But currently, you cannot make any donations through your app that's distributed on iOS through the Apple App Store. Apple strictly prohibits it. There's a number of reasons probably for this. I think most likely they want to stay away from commercial co-ventures and other sort of state regulations that would impact them or may impact them if they allowed you to collect donations through apps. But what that means at this point in time for nonprofits and other organizations who want to collect fundraising through apps is a number of things. If you're going to distribute through the Apple App Store, if you're going to distribute an Apple app, you need to be aware that in order to ask people to donate, you're going to have to take users outside of the app to your actual website, which definitely depletes some of the value of having an app, in my opinion, because ultimately the consumer or the donor interaction is going to happen on your website anyway. Google Play does allow you to do donations through their apps, but they charge, at least as far as I'm aware at this point in time, they're still charging the standard licensing fee that they charge, or the commission basically on the licensing fees, which is 30%. So anytime you buy an app through Apple or Google takes 30 and the developer gets 70. That's true in this particular instance on Google for donations as well. So they're taking a pretty big chunk. Just last month, Google released a new app. I think it's called One Today. It's sort of a donation-centric app. Some of you guys might already be familiar with it. It's proprietary to Google. That seems to have opened up a couple of opportunities because I haven't actually used it yet. Like I said, it's brand new. But you will be able to make donations through that app as a user, and I think there's only like a 1% transaction fee associated with that. So to the extent there are opportunities for nonprofits to get involved and to sort of correspond with Google over how to gain access to potential donations through that system, that might be an alternative for some folks because it doesn't require the investment and you don't have to worry about being constrained by these donation terms. A lot of you probably are way ahead of me on this point, I'm sure, but the one thing that nonprofits still really can grasp on apps, even with these restrictions on donations, is of course friend-to-friend fundraising and sort of the friend message that you use through social networking to get folks sort of excited and rallied around a particular cause. So there is a benefit there, but you just have to keep in mind that actual donation action has some severe limitations through at least the two largest app distribution platforms. As far as data privacy goes, this could be a topic, it could be a whole presentation on itself, but I will just sort of skim over the basics here. You do have to have a privacy policy for each individual app. It's not enough to simply cobble together some terms and to hope that they match what's happening in real life. State attorneys general as well as the FTC are incredibly hot on this topic right now and are actively pursuing investigations of data use through apps. So when you're crafting your privacy policy, you're going to want to work very closely with the developer to make sure that everybody is fully on board with exactly what's happening in terms of that data protection and storage. And finally, just to close out this topic, wanted to touch on a couple of things. I think prior to sort of jumping into this sort of app frenzy, it is useful to evaluate as a starting point whether the app really is the right tool for your nonprofit, taking into account those limitations on fundraising that I mentioned. Can I do that? Hold on one second. We're just having a technical issue. Okay, I'll just go on, ignore what's on the screen for the moment.
We've been having some technical issues. To those of you in the webinar, we've had some technical issues where we haven't been able to see any of your questions to date. I think they're trying to reboot that. But just please proceed, Krista. And for those of you on the phone, just please ignore that little box, which we'll try to get rid of here in a second.
So just a couple practical notes. I mean, when evaluating whether an app is really the right tool for your nonprofit organization, in line with everything we've talked about today, I urge you to sort of keep in mind things like what's your goal with the app? Is it fundraising? And what do those restrictions mean for you? Is it simply word of mouth and social media support? If so, how are you going to track that? And finally, there may already be an app out there that you can work with, that you can use and distribute to your potential donation base that could achieve some of the same goals, because ultimately development of an app is going to run you a pretty steep price tag. It tends to be about 20 to 30 grand for one operating system. Oh, so we're back apparently. So just as we all get swept up in sort of the frenzy to be on the cutting edge of technology, just keep in mind that we really are after certain goals. And the more forethought you can put into whether an app is the right tool for you to achieve those goals, I think the happier you'll be with the results and the investment you make. It does take questions here, but I think we're going to try to hold questions to the end. So I'll turn it over to AJ for the next portion.
And just one side comment before we move on to AJ. When it comes to fundraising, of course, Krista was talking about some of the restrictions that are imposed by certain of the platforms that you may be utilizing. Of course, as many, if not all of you know, there are other issues that come into play in the fundraising context dictated by state charitable solicitation registration laws, dictated by the federal tax laws, and obviously you need to be very cognizant of those issues if you're going down the fundraising path using an app.
Good afternoon, everybody. My name is AJ Zatola. Welcome to the people online, to the people in person. We're going to switch gears now and talk about the cloud. We're having some technical difficulties, so it's going to take away the thunder of my initial discussion point. Oh, we're back. I'm going to focus and linger a little bit on a diagram here because I think it's going to be a nice introduction to this topic if you aren't quite familiar with what the cloud is and what it represents. Try and draw a connection among the four topics we'll be talking about today. I mean, we're talking about apps, clouds, information security, and electronic contracting. You can see the slide before you that has the cloud and a variety of computing devices around it. We started with your mobile device and an app. An app is still a software application. You are actually still receiving a copy of the software to download or store on your own device. The app itself term, I don't know, maybe it sounded trendier because it's a mobile device and an app just sounded like it matched better, but it's still a piece of software and you're still basically receiving a license to use it in a traditional sense like you have for the past 20, 30 plus years. As we move toward the cloud, we are beginning to enter a space where everything you're using is really intangible. You're not really getting anything anymore. There is no downloading, generally speaking, of any software. You're receiving a right to use something. And so more and more of these clouds are services. And so when you're trying to picture what the cloud is, I want you to sort of take a look and focus on this diagram because it can really be any instance where you're receiving remote access to some type of computing functionality. The cloud has really evolved and become almost the norm in a very, very short period of time. And so these days, your computing resources can almost be everything, and all of it can be made remotely accessible such that although we have technical definitions for a variety of things that you may use, at any point, if you're using a computer these days and has an internet connection, you are sort of using the cloud. So if you're getting access to software, if you're using it for data storage, if you're using it for other forms of computing power, you're using the cloud. As we move to information security, as you visualize the diagram here, this is going to be a discussion about instances where you are responsible for, so to speak, the back-end computing equipment. So on the diagram, this would be the big box that you see in the foreground, the background. Finally, on electronic contracting, we'll talk a little bit about how we create contracts, so to speak, between and among these devices, since nothing really is happening in paper anymore. So I'm going to move on to a definition that's been offered by the government. This is an abbreviated form of the definition and actually is used by the National Institute of Standards and Technology to describe what the cloud is. I will tell you this is a little bit aspirational, but it's the government, so these are what they expect to receive as a part of their cloud services. What you see here, again, are some of the things I'm already beginning to describe to you. There's on-demand network access, which is really remote access. You are able to share among many. So if you picture the diagram, it can be phone, laptop, computing device. And it can be rapidly deployed and deployed in a way that kind of matches your needs. So you're no longer agreeing to arrangements where there's a large investment for technology purchases. All that happens in the background. You're just, again, receiving access. I say it's somewhat aspirational because elements of this definition that you see here may not necessarily be what you get when you're dealing with a vendor. But by and large, anytime you're getting remote access to some type of computing functionality or resource, then you should be thinking, I have a cloud device or service that I'm receiving. Now, when we talk about issues and deployment models, I'm going to largely be characterizing, for the benefit of this discussion, everyone as a customer. That's not to suggest that nonprofits couldn't themselves be providers of a cloud service. Certainly, we are talking a little bit about some of the ways apps can be used. If you're storing information on behalf of others, I mean, you might yourself be a cloud provider. But to a large extent, today's discussion sort of takes the view that you are a customer, you are a user of a cloud service. Again, there are a lot of technical definitions for a particular kind of cloud offerings, but we've decided to break these down into some easy buckets for you to understand, because these buckets themselves drive a lot of the issues that you will confront, or more important, can control through your legal contract. Private cloud are essentially private bargains. Okay? The cloud resource is being implemented or operated solely for your organization. That doesn't mean that it couldn't be managed by someone else, but essentially this is your cloud resource. Community cloud indicates that there are several, not the public, but several or more entities using the same resources. A number of your vendors in the nonprofit space actually probably would fit this model because they will tell you that they cater their services to the nonprofit world and that they have resources allocated only for nonprofit entities. But with the community model, by and large, you're still entering into a private agreement, and there is some opportunity to have it be tailored to your needs, or in this case, tailored to the needs of the community. Public cloud, easy examples of public cloud are things like Google Mail. That is a cloud resource. It is also something that is generally available without the payment of a fee. There may be accompanying legal terms, but this is something that you're not necessarily getting a tailored agreement or a tailored arrangement for. And then finally, there are certainly hybrid models. There are instances where storage itself could be private, whereas some of the computing resources generally used. But if you think about these general buckets, and your vendors may use different terminology, it will help you understand those instances where you have an opportunity to manage and maybe dictate or negotiate for specific aspects of your cloud computing arrangement, and those aspects or those instances where you will not. I can tell you that in a public cloud instance, it's take it or leave it. So if you are using a resource such as Google's Docs or Google's email function or the equivalent through Microsoft or even Apple, more and more iTunes is becoming a resource for distribution of media, including academic or other types of materials. You're getting their terms as is. There will be no negotiation, but usually the fee is lower. So you need to take this into account. You can't expect to be in a position to negotiate terms in a public cloud setting, whereas in private cloud settings, or those where there's a smaller community of users, you might have more opportunity to make changes and negotiate as you traditionally might have in the past. So we can't go over all of the issues that you're going to confront on the cloud, but we're going to hit the biggies, and that's generally related to data. Data security, data privacy, or disclosure. When you're using something that's remotely accessible, it's going to naturally be a little less private. There is a need to communicate with someone remotely, and so there is further risk of disclosure. I don't want to suggest to you that that risk somehow is greater than the risks you face internally. In fact, to some extent, it could be more secure. If you were having a discussion, and for the people online, and we're in a large conference room, there's perhaps more opportunity for things to be taken or inadvertently disclosed within this room than there might be through certain secure communication channels. But nevertheless, you are not dealing with your own network anymore. You must naturally connect somewhere else. And so there is more instance for things to be naturally subject to unauthorized disclosure or forced disclosure. Your data may be commingled with others. If you were using public cloud resources, for example, your doc storage, your email storage, that will naturally be occurring through servers that others use too. And so this can give rise to information security concerns. Perhaps they're not necessarily new, but they're new with respect to the fact that you aren't controlling these computing devices anymore. Someone else is. And so there's a little bit of a loss of control here, which if you're going to utilize cloud resources, you just have to kind of come to grips with. This makes trust in the provider and provider selection critical. You need to somewhat manage some of the issues we're going to highlight for you through picking good providers. There's going to be less opportunity to manage through negotiation. The agreement itself may no longer be an avenue to make a lot of changes. I'm not saying that there couldn't be many, but there may be less opportunity to make changes. So when you're thinking about these things and you're thinking about data, it's critical when you're talking to folks to have a general sense of what's going to happen to your data. How's it being transmitted? How's it being stored? How's it being maintained? You also need to give thought to how you're going to get access to your data. Can I have access at any point? Only during certain times? By certain people? Can I get it back? If I can get it back, can I have it returned immediately? Or is there a need for there to be some type of delay? And finally, consider what form the data is being both transmitted and then received back. This tends to be more of an issue when you need something back. And in this case, when we're talking about legal issues, it can be an issue if there's litigation. If litigation involves records or information that you are storing remotely, there can be issues sometimes producing those records in a fashion that meets your litigation requirements. And so again, access, right to receive and get back data are things you need to be considering when you're thinking about a cloud provider. As you're also moving into other issues involving data, you need to be considering the ability to investigate if something goes wrong. You no longer have control, so it's not as easy as walking down the hall to figure out what's going on. You are going to be more reliant on your provider. You need to have a candid discussion with your provider about what happens if there is an incident involving typically threatened or actual unauthorized access or use. You need to give thought not just to implementing these cloud solutions, but also what happens upon termination. Can you reasonably or easily transition to something else? This becomes a little bit more of an issue with services that have larger data storage, but certainly you need to think about what happens at the end of the engagement. One of the promised benefits of cloud solutions is that it's generally cheaper. You don't have to invest in technology anymore. You aren't receiving a copy of any software. And so by and large, cloud resources tend to be less expensive than other traditional forms of software resources. But at the same time, there are things that you don't control. And so you need to understand at the end of your engagement, what do I have, what do I get back, and in what form? Understand that there can be new issues with a third party holding on to your data. You are not the entity storing it or archiving it. And so you are somewhat relying on a third party to do this for you. They may undertake actions that they themselves get in trouble for, and then you necessarily are going to have to deal with that as a user of their service. Moreover, you're dealing with an entity that's not going to be geographically close on occasion. They may be in an entirely different country around the world. And so those third parties and their operations remotely or in another location are things that you need to be considering. An easy one to think about is, will my cloud provider be operating through facilities with computing resources in the United States or somewhere else? If it's in the United States, it doesn't necessarily mean it's better. It just means that at least it's subject to the laws that you are at least more comfortable with. But your cloud provider may use computer servers in a very remote location. There are other places around the world where so-called server farms are just cheaper to utilize. And that also can give rise to even less control, less visibility as to what's happening. So in terms of understanding new issues about how your data is being retained, destroyed, made accessible, et cetera, these are things you need to talk about. How do you talk about them? Just ask. There is greater need now to ask these questions up front when you are evaluating providers. I would no longer recommend that you just kind of go with a single vendor solution or offering. Try and assess more than one. This will give you a chance to determine if one is giving you something better than the other. Now, in the nonprofit space, we're well aware of certain vendors that cater to your needs and that a lot of your other nonprofit colleagues may utilize those same service providers. That certainly can dictate if other people are having positive or favorable experiences. But again, we have found that if you can kind of manage the RFP process, you tend to have a better result than if you focus solely and only on one provider. We're not able to advance next slide. Okay. Hopefully you see the next slide that says there may be less control over disaster recovery. Okay. What we say here is that, again, this idea of control, trust in the provider. You need to understand what happens if there's an incident. You are somewhat paying with a cloud service for the idea that it's always available, always on. And so what they should be backing up that promise or obligation by is having redundant computing resources. If something happens in one location, they can immediately roll over to another. If you're dealing with a provider that cannot make these promises, cannot address this, then it's time to move to another provider. Now, understand that you may not be able to dictate exactly what the disaster recovery response would be, but there should at least be a policy in place so that you yourself are in a position to deal with it. Because what will happen is when you're assessing your own risk management, you're not doing it anymore. You're relying on a third party. And so you're going to need to be in a position to explain, by virtue of what you've heard from your provider, what you're doing. And I can also share that a lot of these providers, particularly those who are in the software business, will often subcontract actual hosting to someone else. And so now we're dealing with a situation where your cloud provider is really two entities, one providing the software, so to speak, one storing the information. And so there's sort of two entities to ask questions about. Now, you will typically only have a contract with one, and it's appropriate to direct all the responsibility to that entity that you have a contract with. But it's also useful to know if they're utilizing subcontractors. Again, this idea of remote access, when you're dealing with data, you're a little bit more susceptible to networks outside your control. The data no longer is coming from a server room down the hall or on another floor in your building. It may be coming from across the globe. So whatever general telecommunication issues exist, that may interfere with an ability to use or ability to get access. So when you're trying to compile all these things and figure out, does this make sense, do know that in many cases, your cloud provider will give you and offer you something that is both far less expensive than what you could yourself implement, but also something that's generally better. They can give you better security, better resources. You may even have the resources internally to manage all the computing that is needed to run this kind of cloud solution that you're thinking of. Your cloud provider can do all this, but there are some elements where you have little or no or a lot less control, and so you have to kind of balance the convenience factors versus the potential costs or loss of control factors. Switching gears a little bit to information security. Understand that this is largely going to be a technical issue, which we'll talk a little bit more in the next segment. But there can be legal consequences if you do nothing. In this case, I'm telling you quite a bit that your provider has a lot of the control. So the legal consequence here is if you don't get a promise from your provider, then you're not necessarily going to be off the hook. You may be responsible for what your provider doesn't do. So remote storage options can be appropriate, but you need to have a provider that's promising you security. They need to have security for the information you're storing. The more sensitive the information, the more security you need, the more measures you need. We talk a little bit about the types of security measures, but the bottom line is seek at least some basic commitment on security. The more detailed the plan, the better off you know it'll be. We talked a little bit about getting access to your data. So in the event of litigation, typically nonprofits don't have to deal with this quite as much as other larger for-profit entities, but it's still a possibility. So you need to understand how you can get access to your data, in what form and when. Most subpoenas, most requests for data information in litigation context are typically asking for all or everything or a lot. And so if your data cannot be returned to you in this fashion, then you may not be in a position to comply. So when you're talking about cloud storage, it's stored somewhere else, not only do you want to know if it can be stored and how you get access to it, you want to know if it can be stored in a way that makes it easier for you to get access to the records in a form that you need to produce. So this may mean on occasion that you need access to particular records or all the records. In either case, sometimes the provider can comply or they can't comply. So again, thinking about how the information is going to be stored and what your access rights will be is something to consider. You may not see any of this addressed in the legal agreement, but it's an appropriate question to ask when you're vetting your provider and seeing what resources they have available. We have a little bit more detail in the slides about problems that can occur in e-discovery settings, but by and large, this is all about getting access to your records in a form that they can be produced. Compliance issues. Well, the good news is there's not really much regulation specifically addressing cloud computing, but that's a yet. Moreover, there's a lot of laws that could apply. Now, many of them actually don't apply specifically to your field, but you may deal with information where there are already laws that would govern. So instances where you have medical record storage, instances where you have financial information, and this can extend certainly to donations. There are already existing laws out there dealing with how that information is to be handled. That will still apply, notwithstanding the fact that the law wasn't really written for the cloud. Moreover, more and more states are instituting more and more state-specific requirements for either cloud computing specifically or more generally actions that relate to cloud computing. One of them is that you're increasingly seeing states get into play certain statutes mandating that information be stored in a secure way. Massachusetts was among them, but more and more states are going to be doing this. Another one is nearly all states have some kind of security incident notice requirement. If data stored on an individual consumer has been left unauthorized access or use, you need to tell the consumer. Pretty much every state has a notification rule for that. So in conclusion, know that we're still sort of at the onset of, legally speaking, how to regulate cloud, but know that many, many people are using cloud resources and it can show up in all different forms. So it's important to think about the cloud as being more than just your device, but really any type of instance where you're remotely accessing a computing solution. You need to talk clearly and communicate effectively with your providers. And if you're on the provider side, by the way, you need to give thought to these issues too about what you're going to tell people so that you're in a position to know how your data is being transmitted, stored, made accessible, and made secure. And in terms of how to utilize cloud resources, balance the cost efficiencies with some of the loss of control I've just described. So we're going to move into a little bit of a category we've entitled information security, even though I've been talking a little bit about that as a part of the cloud discussion. This part of the presentation is largely dealing with what happens. We'll get the questions at the end of the presentation. What happens if there is an incident and what to do about it. To a large extent, you best control your security incidents and anybody susceptible to them by what you do in advance, what you do to plan for such an incident. And that doesn't mean just having information security measures in place or working with a cloud provider to have them instituted. It means what to do if an incident occurs. You need to think about what you're going to say, how you're going to handle it, how you're going to remediate it. Having a basic plan like this can really help you from a public goodwill perspective and also in costs. These incidents can be very expensive, and not because there's legal liability, just trying to figure out how to remediate or address forensically what occurred can be more expensive than anything else. So getting out in front on this is probably the chief thing that we will recommend to all of you. Give consideration to what it would cost to fix. The less you're doing it yourself, the less you need to worry about higher expenses. But certainly you need to understand if there's an incident, if your fees are going to change with the provider. Have a plan. How can you manage your public image? There will be some loss of goodwill if it gets into the public that all the records you stored on your individual employees or individual donors or individual members was suddenly lost. There are breach notification rules, as we mentioned. You can be investigated. More and more attorney generals and the FTC are looking at how information is stored. If you were taking no measure to keep it secure, you could be held negligent. And so understand that when an incident occurs, that's a red flag that you might be further investigated over how that incident occurred and whether or not you were doing anything in advance to stop it. And litigation certainly can result. There's a higher threat of it if you've done nothing to protect your information. But there's increasingly litigation over how records are stored. How expensive? We got a nice side basically saying it can be very expensive. So how you manage this is, again, doing it in advance, and there is insurance that can be procured to cover this. How it occurs, well, most people assume that there's some kind of hacking incident, but to a large extent, there is increasingly a number of incidents that occur just through simple negligence. People put information on a laptop or a mobile computing device and they lose it. You leave your iPhone somewhere and it doesn't have a password on and all the information is available. These, more often than not, tend to be the ways information gets disclosed in an unauthorized way. So don't just assume that there are people out there trying to break in your system. That does happen, but we're largely talking about any unauthorized access to or loss of information, and that can happen through all kinds of events that really don't involve any intentional misconduct. I mentioned that certain states are starting to adopt information security rules. Massachusetts was first. It's not for any and all information. It is specific to personally identifiable information. It doesn't exactly tell you how to maintain security, but does insist that you do maintain security. So if you have records that you're storing on a citizen in Massachusetts, you must have security for those records. You can get a lot of room, or a lot far ahead on this if all you do is encrypt. A lot of times encryption will cover you to the extent you have any kind of legal requirement to do something. I had mentioned that there are notification rules when an incident occurs. By and large, many of them are drafted to say that only on records that were unencrypted. So if you encrypt, you may not necessarily have an obligation to disclose. In this case, you're seeing a state-specific information security statute saying you must encrypt. This is a technical measure that maybe not all of you fully understand, but certainly when you're thinking about your cloud resources or your own internal computing resources, you must have security. You need to consider and talk with your technical personnel about encryption. Education and training, this means that you have a policy in place to keep things secure. This can dovetail nicely with a general confidentiality policy, and that you put this policy into writing and educate and train. Some of these things you certainly have been dealing with all along for other types of confidential and sensitive information. Now you're seeing it take the form of stored records, oftentimes for personal information, but we're likely to see this grow. In terms of these notification laws, I've been talking a little bit about them, so I'm going to kind of skip over this. But the bottom line is, if you are subject to an unauthorized security incident, you may need to tell people about it, meaning you may need to be in a position to inform. You need to know whose records were accessed and then get in contact with them. You're beginning to hear that this can take a lot of legwork sometimes if you hadn't been planning in advance or don't have a policy or approach you're dealing with, or haven't asked your provider how they're going to deal with it. Hopefully your provider has these policies. Don't be afraid to ask these questions. How to protect your data? Well, more and more you're not really storing it someone else's. So you do it through whatever measures they have instituted. You may not be able to dictate precisely how they do it, but at a basic level, make sure that they have some promise to keep your information secure. In terms of your own computing equipment, basic stuff dealing with confidentiality. Have passwords, educate about keeping things secure, don't give access to everyone. Lock doors to records. Some of the same rules apply here. So you don't need to reinvent the wheel for this. Just know that you need to make sure your existing rules or approaches can work with electronic records, including those records that are stored remotely or on devices you can carry around. In terms of tactical recommendations, what works best, we've given you a slide to think a little bit about how you get the most bang for the dollar. I think when you see this, though, you'll see that there are some reasonable measures that are cost-effective that you can implement. So at the end of the day, you can take some or institute some security measure, but you're not going to be left off the hook if you do nothing. Just because you're a nonprofit, will anyone take pity on you? They will expect you to store and secure your information. What to do when a breach occurs? Well, you need to deal with it immediately. That's something that pretty much everyone would expect to happen. You can't let it sit. You probably need to figure out what happened. You're probably going to need to figure out whether or not you need to provide notice, as we've been talking about, to individual consumers. Know that the obligation to report is not always mandated. It's going to be triggered or mandated or set by state-specific laws. But to a certain extent, those laws are dealing only with personally identifiable information, meaning not business records. And they're talking about instances where you haven't really done anything to protect your information. Finally, you may need to say something to others. And so, you may need to give thought to making some kind of public statement. You certainly hear about this in the news. You read about it in the news. These are instances where people are made aware of an incident and it gets out in the news. What are you going to say about it? Are you going to say, whoops, we didn't do anything, our bad? Or do you have a measured response to indicate that certain security measures were taken, something inadvertently happened that you couldn't control, but you're taking steps to remediate? So in conclusion, give thought to how you're storing the information. Make sure you're trying to protect it in some respect, either directly or indirectly. Have a policy for the foregoing, and make sure you educate all your personnel about this.
Thanks, AJ. So our last topic today, electronic contracting. It's a good one because the upshot is quick. Can you create a contract inadvertently through email? Yes, you absolutely can. The same rules apply to contracting online that applied when we learned them in first-year contracts for those of you who are lawyers. I'm not going to keep this slide up too long because it gives me nightmares, but a contract is an offer, acceptance, and consideration, or something of value that each party brings to the table, basically to prove that each party has skin in the game, that there's something to bind both parties there. It has always been the case that a writing is not necessary to form a contract. When those three elements are present, it's certainly possible to form a contract orally or on a handshake or in any other number of ways. There's some exceptions to that, most notably the statute of frauds, which is state law framework that says certain types of contracts, the big ones being real estate contracts, contracts concerning personal interactions like marriages, adoptions, divorce, that sort of thing, contracts for sale of goods over $500, and I think services contracts that can't be performed in less than a year are sort of the major categories there. Those have always been required to be in writing by the states that have adopted those as statute of frauds. And then federal law has certain quirks as well, especially with regards to IP, concerning what needs to be in writing and when. Those are the laws that primarily have been impacted by the passage of by one particular federal law, which is called the E-Sign Act, and a number of state laws, uniform state law that basically tracks closely, at least in its uniform format, the federal E-Sign law. These basically say, and I'm not going to go through them in detail, but that electronic signatures are valid signatures. So for contracts that are required to be in writing, electronic contracts will suffice, and electronic records will suffice. There are a number of rules with regards to these two statutes, but the big point here, the big thing you need to keep in mind is that they're based on the intent. It's based on the intent of the parties. So if you create an impression that you are okay to do business online, that you are inviting others to do business with you electronically, basically you've given your intent to contract electronically. One of the hypos that's frequently given is if you hand out your business card at a trade show or some other event and it's got an email address on it, you've basically said, I'm okay to do business online. That doesn't mean, however, that you're without recourse or protection. I mean, one of the big things you can do in order to make sure that when you're corresponding with somebody online over email about what your potential business arrangement might look like, you can always include a disclaimer saying that this isn't intended to make a contract. This is just a preliminary discussion. You can also refer to a required later formal contract on paper. Do things like that to sort of completely dispel this notion that you are volunteering to do business electronically. Because courts have found, especially in recent years, that conversations over email concerning even real estate have amounted to binding contracts. They've frequently found that conversations over email have amounted to amendments to existing written contracts. So all of this is just by way of saying, definitely when you're corresponding with folks over email in particular, be very aware of what you're saying and make sure that if there's any offer at all, if you're making any proposal for business terms, or if you're responding to an offer, that you're very clear that what is not, that you're not accepting, you're not entering into a binding contract at this point. It's just a preliminary discussion. That's really the best avenue for protection at this point.
And in the nonprofit context, we see this come up quite a bit in the area of hotel contracts and negotiations over hotel contracts. Frequently, nonprofit staff are negotiating with the hotel staff over the terms of a contract, maybe about amendments to a contract, maybe about windows within which you can revise the targets for attrition penalties, or revising the time period for when you can cancel the agreement. And there's a lot of back and forth by email. Obviously, most of the time, those negotiations will then result in a traditional written contract that gets printed and signed by both parties. Maybe it's all done electronically, but not always. Not always at all. And if there's a negotiation that goes back and forth and then say it never turns into a written contract, but one side or the other believed that they had a deal and relies on that exchange and then makes decisions based on that ends up, say, foregoing other business, or maybe the nonprofit is relying on it and they don't go ahead and secure some other venue for the meeting, and then a year passes and it turns out the hotel said, well, we never had a contract, so we didn't reserve the space for you. And the nonprofit is out of luck because it has no recourse and no place to hold its meeting in that particular city. That's when these problems arise, and we've seen them arise quite a bit. They often don't result in litigation, but they often do result in disputes. They result in problems. And like Krista said, the best way to deal with this is to be very explicitly clear whether we're talking about an initial negotiation, a negotiated amendment to an existing contract, that you make very clear that none of this is binding unless and until you have that final signed contract or signed amendment. And of course, make sure you follow up and get that signed amendment. That's the best way to protect yourself. Okay, at this point we have left a good amount of time for questions, so we want to kind of open the doors for questions here in the room, and for those of you on the webcast, please pose your questions using the chat feature on the webinar software, and I will pose those questions to our speakers on any of the topics we've covered here today. And for those of you in the room, Kelly has a microphone there, so everyone will be able to hear on the phone.
In the trademark area.
Is that on? Is that on, Kelly?
Yeah. In the trademark area, often an association has a choice. They have an activity. It could be either a product or a service. Is there some value to saying it's a service mark versus a trademark?
The distinction is somewhat... The question was, is there some value or some benefit from designating your trademark as a trademark or a service mark? The short answer is not really. The distinction is somewhat of an administrative distinction created by the Patent and Trademark Office to classify your associated goods or services. So trademark being for tangible items, service marks being for intangible. But there is no harm in using a service mark to identify services. Moreover, it's okay if you use a trademark to cover both something that's tangible as a product or a service as well.
I would add, and these guys know this stuff better than I do, but I have been around nonprofit trademarks for a number of years. Problems that we do see, not in that area, identifying or registering as a service mark when it should be a trademark or vice versa. We definitely see problems where a nonprofit will register something as say a service mark where it should be a certification mark, or as a service mark where it should be a collective membership mark, or vice versa. These are other categories of potential registrations that have very defined uses and define the rights that you have and don't have in those marks. So it is very important that you pick the proper category amongst trademark, service marks, certification marks, and collective membership marks. In addition, another area where we commonly find problems, in fact, I don't think we've ever taken over a nonprofit's management of a nonprofit's trademark portfolio where we didn't find multiple cases where the marks were registered in the wrong classes. So in addition to picking the type of mark, you have to pick what classes you're registering the mark in for the various specific types of products and services that you're providing. And if you don't register in the right classes or in enough classes, you may not have the broad protection that you want. And probably the last big problem that we see a lot is nonprofits registering, for instance, the logo, maybe it's the name of the organization, the name of a program, a product or service, but not registering the words alone as a separate mark, or vice versa, registering the words but not registering the design. Generally speaking, you're going to want to pursue federal registrations for both because they give you different protection. The registration for the words is going to protect and give you priority rights with respect to someone else using a confusingly similar variation on those words, whereas the registration for the logo is going to protect the overall design. And then finally, there's a lot of other nuances in this area, where you have a very descriptive mark that doesn't qualify for initial registration on the principal registry. There are other things you can do, such as pursue secondary registration that doesn't have as many rights as the principal registry, but where you can move it to the principal registry 5 years later. And you might also be able to immediately pursue registration for the logo on the principal registry. So those are some things to keep in mind. Other questions? Actually, we have some here from the webinar. Krista, you covered this. Regarding the work made for hire issue, can you detail some specific situations where we need to be concerned about contracting around copyright law?
Yeah, I mean, the big one that I sort of intended to touch on while I was talking was just that fact that a work for hire has to fall into a certain number of categories that are enumerated within the Act, one of them being audiovisual works. So typically, in the context of an app, your work will fall into that doctrine, and so you just need to be concerned about getting that writing. But ultimately, copyright law governs. So if a court were to find that an app were not an audiovisual work or any of the other, I think, 8 categories enumerated there, the fact that you've called it a work for hire isn't going to do anything. That's the instance where you need to rely on what is hopefully a well-crafted work-for-hire provision that has a fallback that says if a court finds this not to be a work-for-hire, the developer hereby assigns all rights and interests to the nonprofit. And then sometimes you even take it one step further and say if any of these rights cannot be assigned, the developer hereby grants the nonprofit an exclusive license to use and agrees that it waives and won't assert any intellectual property rights in that property. So that was sort of the one thing I was wanting to make clear, that it's not enough just to say it's a work for hire. It really does need to fit within the framework.
And Krista, isn't it customary to almost always have that kind of fallback of an assignment if it doesn't qualify as a work made for hire?
Yeah, it absolutely is. I mean, I think that's like one of the points about you can call it what you want, but you just got to have it drafted in that right way. It's one of the niggly lawyer things.
And there, from what I understand, there are some benefits to something being captured as a work made for hire as opposed to an assignment. The rights of the recipient of those rights are greater if it's a work made for hire as opposed to an assignment in terms of the duration of the copyright and certain other things. I'm not fluent in all the nuances.
You will be entitled to claim author rights in a work for hire situation, whereas in an assignment scenario, there will still be an author. You will merely be the claimant and owner of the work. So there are instances where work for hire can be to your benefit, but in the nonprofit example, we tend to see instances where people just assume that if they say the words work for hire, that magically transforms the work into something that they own. Designation or declaration of work for hire isn't enough. As Kristen notes, it's got to fit within the enumerated categories and descriptions, and by and large, in your case, there may only be two: your own employee's work, or if you hire a single entity or author to write a series of articles. Beyond that, most work for hire categories will not apply, meaning you must have an assignment grant in writing that expressly states that the work is being transferred or conveyed from party A to party B. That written conveyance is a requirement to transfer, similar to the rules in real estate. If you don't have it in writing with an express transfer and assignment grant, you haven't effectively transferred. Now, if all you have is a designation of ownership, we probably can fix it for you, but you haven't actually gone yet through the steps of getting ownership. So there's something that's critical to understand in any development contract. If it just says you own, or the contractor consultant says you own, that's not enough. We want to see the assignment grant as well.
Yeah, we've even reviewed nonprofits' copyright assignment forms, I'm using my air quotation fingers, that don't have the actual language to effectuate an assignment. There's no specific magic language that has to be in there, but it does need to make clear that it's transferring ownership. It doesn't matter how much you're paying for it. If it doesn't have the language in there, you don't own it. And of course, once you get an assignment, AJ, the recipient can then register with the work with the Copyright Office.
Correct. The claimant is just as entitled as the author. And in fact, when you file for a copyright application, you need to name both. So when you actually are the author, your entity or your employees wrote the article, you can claim and file by yourself. When you're doing it with a contractor who actually was the author, you need to still name that author. So we sometimes get questions about plagiarism or what rights the author has. Or you're dealing with an author that's doing it for free. The author always is the author, but your rights to claim ownership over and control over the work will vary based on your role in the process. And so when you are thinking about these issues, it's critical to think about who actually is creating the work, and if it's not your organization or your employees, did I get an assignment so that you're in a position to claim what rights you were entitled to?
And as I indicated earlier, AJ said with employees, there's an automatic work made for hire transfer. You don't have to have anything in writing. It automatically transfers from the employee to the employer so long as the work is done within the scope of that employee's employment by the organization. For paid contractors, AJ just talked about it, but these rules also apply with your volunteers. The nonprofits heavily rely on the copyrightable contributions of their volunteers, but unless you have an assignment in writing, all you're going to have is some form of a license, which is just permission to use, but it's going to be limited. If it's not in writing, it may be a question as to what the terms and scope and duration and terminability of that license are, whether there's potential royalties involved. It can be an absolute nightmare. So with all of your volunteers who are submitting articles and PowerPoint presentations and letting you record their speaking presentations and serving on committees that are creating written work product or new certification programs, with all of these folks, you want to have a simple copyright assignment form that transfers ownership.
I always tell nonprofit clients, just get an assignment when you can. Don't even try and figure out if you have some other vehicle to claim ownership. Just if you have an opportunity to have an assignment put into place, then go ahead and get it. Don't worry about the rest, because with the assignment, you at least have confirmed your rights.
And then finally, the other two of the other big tips we're always giving in this area is once you secure those rights, put people on notice of those rights by using copyright notices, the little C with a circle around it, or the word copyright spelled out with the year of initial publication and the name of the copyright owner. Use that on in at least the cover page or the home page of everything that's subject to copyright protection, and register your works with a Copyright Office. Very simple, very inexpensive. You don't need a lawyer. You can do it yourself on staff. and we could talk quite a bit about how that significantly enhances your rights, especially later if someone is infringing your rights, which happens all the time in the nonprofit world. It makes all the difference in the world between a viable claim and settlement that you may be able to get or a lawsuit down the road. Quick question here. Once a contract has been signed electronically, what opportunity is there to nullify the agreement, for instance, if it was signed accidentally? Really no different than any contract. Anytime a contract is entered into by two parties, if those same two parties come together and want to modify or nullify the contract, they can do so, but both parties have to agree to it. Otherwise, it's just going to depend on the terms of the contract. Contracts will often say that one party has some unilateral rights to do certain things. They might have a right to terminate, at the end of the term if they give 60 days prior written notice or other things like that. But those unilateral rights are only going to be what's spelled out in the contract itself. Other than that, though, two parties can always come together and change a contract at any time.
Let me add in one point about this, because in a lot of instances you were all confronted with legal terms online that give the other party a lot of contracting power. I can tell you that even though many of these documents are not contested and made enforceable through a court ruling, a number of them just are not as enforceable as the terms suggest. You still need to form a contract. There needs to be mutual agreement. If that has not occurred, I'm not saying that someone wouldn't argue that a contract has been made, that promises have been made, but without actually going through the process of forming a valid contract that you can both record and have both sides validate in some respect, then the issue of whether or not you have an actual contract in place is always going to be in play.
Mary, you had a question?
Yeah.
There's a microphone.
Thanks. Just going back to data protection for a minute. Can you talk a little bit about the bring your own device policy, pros and cons, or why that's recommended?
As a general step, you should account for whether or not your organization will allow nonprofit information to be stored on mobile devices. I can't tell you if that's a good or bad idea, but you at least should account for it. And if you are going to allow it, you need to consider what people are allowed to store. Because if you're not doing this, then a mobile device, and I'll include in this description a laptop, is an easy way to lose things. Laptops in particular seem to get left on park benches all the time. It's usually a government official in this town for whatever reason. But there is many cases when people are describing security incidents, it's typically because somebody lost something. They left it in the cab, they left it behind. And if that device contains sensitive information and you have no policy dictating what should have been on it in the first place, I mean, to a certain extent, any liability or loss that results could be the organization's fault for not having dealt with it in the past. And so if you're looking for some recommendations upon what to do with bring your own device, because everybody has their own phone these days. People use laptops to connect. We're no different. Our suggestion to you is to try and store nonprofit records centrally, meaning not on these devices, and that you have some ability to control access to your own internal network through password, and that in terms of other things that might occur on the device, particularly the mobile devices that everyone carries around, that you articulate when the communication is on behalf of your entity and when on behalf of the person. We have our own internal email network that we use, so even though I might have a personal email account, I never use it for my work. All work emails through my work address, through my work account. I also don't use my work address for anything personal. That kind of simple distinction designation can sometimes be an easy policy to manage people who are going to come to the office with a whole bunch of different devices that you're not going to have any control over.
Okay. AJ, question with respect to cloud services, separate from data storage or software use, are there particular concerns to be aware of in transitioning to a cloud-based email service such as Microsoft Exchange hosted by a community provider?
I could articulate concerns, but if you're moving to a general provider like that and you're not really paying for any special treatment. And in many instances in the nonprofit space, you're taking advantage of the lower costs. You're not really going to be in a position or have any leverage to force change through negotiation. You're kind of stuck with what they have. And so one of the things you can do is at least have a better understanding of what your rights and entitlements are as a customer under that kind of service arrangement. Starting there is a great way to work through some of the issues that we had raised with you. Articulating, understanding better what the security policy is, what the disaster recovery policy is, what the right to access records would be. Microsoft will be able to at least give you this information, even if you're dealing with them on a completely remote electronic basis, and a lot of times you are these days, or you're working with one of their vendors that will tell you, I don't know, it's whatever Microsoft says. They do put that information online. Print out a copy of that policy. That is, in effect, a part of your service, that policy statement. That would be what you rely upon if someone asks you what you are doing on the security front, on the storage front, on the disaster recovery front. Now, as to whether or not cloud storage works for you, as to whether or not it's a good idea to use somebody else for email, the bottom line is we all use other providers for email. We are all reliant on other providers for email storage. And so it's easy for me to tell you there are risks there because of the loss of control, and there are. But the fact remains that's what we all use. And so as nonprofits, and really typically with what you are able to control, and to a certain extent it's not that much, a good first step is just understanding. And your understanding could be, oh, I'm not getting any promises. If that's helpful to know, because then you at least have made that cost-benefit analysis of whether or not it's worth it to go with a solution that's low cost or free, where you're getting no promises, versus some other alternative solution that costs more, where you're in a better position to ask for certain policy, certain commitments, certain covenants.
Thanks, AJ. Okay, another question. Oh, sorry, I didn't see the question in the room. Go ahead.
Right. Thank you. The Massachusetts Data Security Statute, what does it take to be subject to that? Is it just having a website, or do you have to have an online store where someone purchases something from?
All of these state rules are going to be driven by whether or not you are dealing with a resident entitled to benefits under that state law. So the notification laws, the security laws that are coming online, think of it as a state entitlement that a resident might be able to claim. Now, understand that in a lot of these cases, you may not have any right to private cause of action, meaning no one can sue under these laws. But certainly the state attorney general, the state can enforce them. And so you're trying to figure out if you need to worry about this. I think the first place to start are, do you have any employees that are Massachusetts residents? Or would you be knowingly working with folks who are in Massachusetts, they're residents of Massachusetts with a Massachusetts address, and you're storing their personal information? Inevitably, you might have to comply, but that's a good place to start.
And AJ, by the latter, you're referring to potentially members, donors, others whose personal information you might be storing.
Correct.
Yeah, and that I think answers the question to someone on the phone. Do the state regulations for data apply based on the state of the head office only, or different states apply based on the location of remote workers? It sounds like from your answer it's certainly in any place where you have employees, whether they work in a physical office that you own or rent, or whether they work from home, that's generally going to trigger coverage of those state laws, as well as wherever the personal information of those members, donors, customers, certificates, others for whom you may be storing that data.
If you think about incidents and resultant investigations or even lawsuits, there's got to be some nexus to the state. So when the Attorney General takes the stand and says, we're suing, he's got to be able to make the connection to his own state residents. He can't do it on behalf of someone else's state. So, it sometimes can be difficult to know if this is actually going to apply, but it's important to be thinking about this from the individual's level. It's no longer quite as relevant if you have a facility or a business address in a particular state. These record laws, these notification laws tie more to the information and the individuals with whom the information relates, less so that you're actually conducting business there.
Yeah, question over here. Just if you can hold on 1 second for the microphone.
Do Maryland and Virginia have some version of this Massachusetts data security statute?
Not as yet, but I can tell you that everybody's looking into it. A certain point will be reached where even if you don't have every state having one of these types of laws on the books, there'll be enough of them where you almost have to have 50-state adoption. The same holds true with notification. I believe it's 48 or 9 of the states have a breach notification law. So that's not everybody. You might ask why the federal government hasn't stepped in and come up with a universal standard for some of these things. Frankly, on notification, a federal level standard would make a lot of sense. But these days, not much ever seems to happen there. So you're left trying to comply on a state-by-state basis. What we tend to recommend sometimes when your operations are in a lot of places is we will sometimes just pick out the strictest state and say if you can be compliant there, you're probably okay in the other places. And on these kind of laws, California is a great place to evaluate because you have, all right, go ahead.
No, we were just talking about that.
But Massachusetts or other states that are tech-driven are good places to look. Now, I'm going to contrast this by something on the electronic contracting front. Virginia and Maryland are the only 2 states that have a law dictating when electronic contract is formed. No one else does. And that might sound like the states are very progressive, but the problem was that no one actually liked the statute that was enacted. So there are actually states that refused to follow it. And so when we describe or talk about electronic contracting, we tend to bring you back to basic contracting rules, and we don't focus quite as much on what these particular statutes state.
Question right here.
This is related to copyrights. Sometimes when they change every year, I've noticed that sometimes they have a copyright and they don't have the year. How important is it to have the year and update it every time? Is it just as valid if it just says copyright and owner?
I mean, it is valid in that it's giving notice that the work is copyrighted. And the true benefit of that is that if there is an infringement, the claim then becomes willful infringement because you've put the person who's using your work on notice that you claim copyright ownership in that work. But copyright attribution generally should include the copyright notice, the name of the copyright owner, and the year, in large part because you want to make sure that you're getting that you are conveying that the most current version of any given work is the one that's protected. So, to the extent that you are not 100% on top of changing all of your dates to 2014 on January 1st, I don't think it's a major cause of concern, but it's a practice that you should put into effect as soon as you can, just to make sure that you're constantly claiming and conveying copyright ownership in the most recent version of the work. That way you don't lose protection for any of the changes, or at least lose that willful copyright infringement claim for any of the changes from an older version to a newer version.
And Krista, is there any advantage? Sometimes you'll see a copyright owner use a notice that has the year of initial publication. So it'll say, 2003, 2007, 2011, 2013. Is there any advantage to doing that? Any reason, benefit?
I mean, the historical reason behind that has largely been mooted. I mean, there was a point in time when the length of your copyright depended on the date it was first registered or first published. At this point in time, you have copyright ownership over anything you create the moment you create it. The slight benefit to having a history like that, I guess if you're looking for one, is that it will put the users on notice that there are multiple versions. And so you are putting them on notice, and you are basically claiming to the world that every version, regardless of the differences between them, has the same degree of copyright protection. But really from a legal standpoint, there's no need to do that. It's just one notice with the most current year will give you the protection you're looking for.
It can trigger duration of ownership, but the term is so long that for your purposes, it's not really meaningful.
Especially in the technology context.
could you just say, 2000, year 2000 to current year, so you don't have to do this extra administrative?
For better or worse, they actually require you to designate a year. But if you're dealing with a work that has incorporated works published first within a range of years, we usually just tell people to pick the earliest year and then the current year. That's your range. Yeah, because notwithstanding that notice declaration, if you ever needed to enforce your rights, that in and of itself isn't going to dictate anything. It may be meaningful at some point. It may be evaluated, but it's not going to be confirming anything.
Yeah, frankly, what's much more important if you come into a situation where you find, and of course, by the way, we didn't talk about policing, but policing your intellectual property, your copyrights and trademarks, to make sure policing the web, policing other media and other uses to make sure that your intellectual property is not being wrongfully infringed. And then when you want to follow up on that, and you want to threaten a lawsuit or file a lawsuit, that's where the copyright registration becomes so important. Your rights become so much more enhanced. Like Krista said, you get copyright from the moment that original creative work is fixed in a tangible medium. You own the copyright from that moment forward, regardless of whether there's a copyright notice attached to it and regardless of registration. But that registration is so important, and it's so easy to do. Trademark registration is equally important for other reasons. Unfortunately, that's a more cumbersome, expensive, difficult process. Very important. You usually do need outside counsel or inside counsel. You need a lawyer typically to help you with that. But copyrights, it's so easy to do. It's something you really need to get in the habit of registering all of your copyrightable works with a Copyright Office on a regular basis.
And just one more point to that effect. If you're not in the habit of registering your copyrights and you do find yourself in a dispute about ownership over something, the first thing your lawyer is going to tell you to do is to register the copyright, because you can't bring a claim in the United States for copyright infringement unless you have a registered copyright. And it's possible to do that on an expedited basis within a matter of weeks, but the fee quadruples, triples or quadruples, I forget what it is, in order to do that on that expedited basis. And also that puts you 2 or 3 weeks behind where you'd like to be, especially if you find yourself in the position of really wanting to run into court with a temporary restraining order or something to really take aggressive action to protect your copyrights. If you haven't registered, as Jeff mentioned, you're behind the ball and you're facing higher fees and a delay.
And in addition, if you want to be able to claim statutory damages, large damage amounts defined in the statute, as opposed to having to prove actual damages, meaning actual financial harm, which can be very difficult sometimes to prove meaningful numbers in the nonprofit context, you have to have the work registered either within the first 3 months of initial publication or before the infringement occurs. You could still file for the registration and then file suit after the infringement occurs, but you're not going to be able to claim statutory damages, which is a huge, huge difference in the nonprofit world. Okay, one final question here in the room, and then we're going to wrap up.
To what extent are you finding associations in particular copyright their events, like their conferences, institutes, that kind of thing?
Well, it's a good question. And when you say copyright your events, your conferences, your institutes, what you're really talking about is how are we protecting the various components that make up the value of that conference. And conferences for so many, not just associations, other nonprofits, are incredibly valuable. I mean, for a lot of our clients, it's their biggest revenue generators by far. And so you need to protect those things. But typically, the primary forms of protection are through copyright protection and trademark protection. You definitely need to protect the name of the conference, the logo, the slogans. There may be subparts of the conference. There may be events. You know, a lot of our clients have big conferences that have different events that go on. There's a trade show within the conference. There's a special hall that does this. There's a special evening of events that do this, and they have different names attached to them. You might want to pursue protection of all of those things from a trademark perspective: registrations, trademark notices, etc. License agreements when you're allowing others to use those names, when you're bringing in sponsors or others, vendors who are going to help promote the events. You want to enter into written trademark license agreements to govern how they're going to use those marks. For the copyrighted material, like the educational content, for instance, you definitely want to protect that. You want to first secure all those rights, get the assignment of all the handout materials and the PowerPoint presentations, and get rights to record the speaker's audio and or video, record the speaker's remarks, and then capture those in a database that you can then use for any purposes that you want in the future, including at future conferences. So you want to secure those rights and then protect them through copyright notices, registrations, etc. And then, of course, there are other components to a conference, that aren't intellectual property, but that may be, relationships with your vendors, a management company that runs a conference. There may be key employees. There may be other things where you generally want to protect the rights through contract. So contractual relationships with different parties to help secure your rights. And even there's a lot of conferences that we're involved in for clients that are joint ventures between different nonprofits or between a nonprofit and a for-profit. Those agreements are absolutely critical to carefully negotiate and draft because they can be a nightmare if you end up in a dispute. I mean, we have one client that has one of the most successful shows in the country. It's a partnership between two different nonprofit organizations. One is much more dominant than the other and would love, that's our client, would love to break away from the other organization and be able to control the show on its own, but it's locked in because there was a really poorly drafted contract entered into years and years ago with no ability to get out of it. We've tried to renegotiate it and just can't. And kind of the two parties are stuck in a marriage that really no one wants. But anyway, on that note, we're going to wrap up today's program. Thanks to our speakers for a terrific job. We really appreciate it, and we hope to see you back here next month. By the way, that program I mentioned is on October 7th, association-sponsored market research programs, common pitfalls, antitrust risks, and opportunities. And then the college and university program is on October 24th. Hope to see you back next month. Thank you.